This is an application in the matter of death and safety of state to council.
Yes.
May it please the court, I appear for the appellant along with Ms van der Meer. Mr Ormondrod appears for the respondent. The court hopefully should have a permission to appeal bundle, a core and a supplementary, and the appellant skeleton is within that, pages 16 to 31 of the core bundle. Separately, hopefully the respondent's statement on permission to appeal and short supplementary skeletons from each party. Apparently the respondent's short supplementary has just been handed up in hard copy. The appellants will follow with the kind assistance of the court.
Are so that and your supplementary skeleton aren't in the bundles?
Yes.
We found our way to them.
I'm very grateful.
Is there a reason that they're not in the bundles? I mean, I know this case originated from the administrative court, which
yes.
procedurally is the Wild West, but we do quite like to have the papers in advance. The authorities came yesterday.
Yes. Yes, I think we had not entirely appreciated in terms of putting all the papers together, the difficulties that the staged approach, especially in relation to the skeletons, would cause. So we apologise for any difficulties that
All right.
caused.
Well, notwithstanding the Wild West nature of the preparations, we have actually read everything and we understand the points that are made. So orally, Mr. Hon, you'll cut your cloth accordingly.
Yes.
Because, as I say, I think we have a lively appreciation of what the issues are, but do make any specific points that you want.
My Lord, I'm most grateful for that indication. And again...
I thought we heard about a respondent's notice. Oh, yes, that's a point.
Not a respondent's notice, but the respondent's response, so the short response that usually provided when an application...
The Rule 19 response.
Rule 19, paragraph
Yes.
19.
Oh, yes, we've seen that.
Yes.
No, it was somebody else who used that language, but we just needed to clarify that there isn't a response.
No.
Good.
No.
Thank you.
No, that really would be the Wild West, I think, if one was to pop up right now. So,
Sorry to interrupt.
no, not at all, my Lord. So I propose to structure my submissions as follows, and would hope that this would take around an hour, with the indication from the court of pre-reading. I'll begin, if I may, with the statute, looking at its purpose and meaning. I'll then move on briefly to the revoked statutory guidance and the 2004 guidance. I'll then cover very briefly the reasons for the immediate withdrawal of the statutory guidance, and then alight on each of the grounds in sequence.
Okay.
So if I could begin then in the statute, that's in the authorities bundle, tab 2, page 6. Authorities bundle, tab 2, page 6, which is the very front page of the Traffic Management Act 2004. And just to note on this page that the description of the Act makes clear that it is an Act in the second sentence to make provision in relation to the management of road networks.
Yeah.
And on the next page, page 7, we see the beginning of part 2, the network management by local traffic authorities, and in the skeleton, the court will have picked up that that's the majority of roads. And there's the general duties then relating to network management, and then we have section 16. And in my submission, it's important to look at and appreciate the whole of section 16, 1A and B together, in order to understand both the statutory purpose and the extent of the network management duty. Under paragraph 1, the statute makes plain that it's the duty of the local traffic authority to manage their road network. And I emphasise that, with a view to achieving, and then there's the caveats about practicability and reference to other obligations, particular objectives A and B that are set out, and A being securing the expeditious movement of traffic on the authority's road network. I will come back to that, but just to note, paragraph 16.2 starts with the action that the authority may take, which indicates that management of the road network is about authorities taking action in performing that duty. Paragraph 17 on the next, section 17 on the next page makes it clear that there are arrangements that can be made for this undertaking of this duty in relation to the actions that can be taken. And then section 18, which is important as well, in relation to the guidance, it's important to note that the guidance focuses on, in the second sentence, guidance about techniques of network management, where appropriate, where the Secretary of State wishes to publish such guidance. So it's techniques in relation to the performance of the duty. Now, standing back from all of that, the approach of the judge below and indeed of the Secretary of State in addressing this statutory construction is really to focus the statutory purpose on little a, section 16(1) little a, securing the expeditious movement of traffic on the authority's road network. And the court will see that in the Respondent supplementary skeleton at paragraph 5, where there's a cross-reference to paragraph 44 of the learned judge's judgment below. But with respect, that is not right as a pure articulation of the purpose of the statute. The purpose, as we've just seen from the language, is the management of the road network in relation to this particular objective. So stating the purpose just as generally securing the expeditious movement of traffic is to essentially position it as a high-level outcome-based act, but it's not. It is a management duty. So the purpose, at least partly in relation to part 2, is the management of road traffic, of the road traffic network, through the management actions that are taken. And that means actions not just in relation to cars, but it's common ground, that is action in relation also to cyclists and pedestrians. And that means that the purpose of at least part 2 of the Act is to impose a duty on local authorities to take action to manage the road network, to secure the expeditious movement of pedestrians, of cyclists, and of cars. And that's why it is, at least for present purposes, arguable that the appellant's submissions around the withdrawal of the statutory guidance removed guidance about the techniques of the network management and therefore impinged on the purpose of the Act. And the court will see in relation to the statutory guidance that in the core bundle, if I can just ask the court to turn it up at this point, on page 142, towards the end of the bundle, the statutory guidance itself makes plain in its title, made under the Traffic Management Act, that it is network management to support active travel. And that links back to what I've just been emphasising as the purpose of the Act being about managing the road network, and this particular statutory guidance going to the active travel aspect of that, which is pedestrians and cyclists. So given that it's common ground between the parties, that the movement of traffic includes all three things, cars, cyclists, and pedestrians, this part of the guidance, this Traffic Management Act guidance from April 2022, is the only mechanism which provides, in the words of section 18, the techniques of network management relating to pedestrians and cyclists. The 2004 guidance, the court will have seen, essentially says something very high level about acknowledging pedestrians and cyclists need to be accommodated. But in terms of setting out what Section 18 is talking about, techniques of network management, that is found and found only in the withdrawn guidance.
Yep.
I'm very grateful. So, the respondent says, well, the act is value neutral, the duty is value neutral, because it affords every method of traffic, cycling, walking, the same importance as the use of cars and other vehicles. But that, in fact, is to make the appellant's point. Because if that is right, then it is a key part of the purpose of having a duty to manage the road network to secure a particular outcome, that that duty is equally exercised in relation to all of the modes of traffic that fall within it. And that's really the thrust of ground one. We're dealing here with a management duty that requires certain steps to be taken to secure the expeditious movement, and the techniques that are relevant to that in terms of guidance are found and found only in the withdrawn guidance. And given the legislative purpose is the management of the road network, then it is at least arguable that the withdrawal of the guidance was contrary to that purpose. To the extent that the court is assisted by not just looking at the words of the statute, but also looking at other helpful elements which bring the purpose of the statute to the surface, that was the appellant's sort of second part of the argument under this interpretation point, which is that the court can have regard to the non-statutory policies that have been made, which are relevant to either directly because they're the guidance or indirectly because they touch upon active travel and are then mentioned in the guidance, which are relevant to active travel. Now, the court will have seen that there is something of a disagreement between the appellant and the respondent, and indeed the judge below found that this was not the correct approach to statutory interpretation. There's somewhat of a disagreement about the correctness of having regard to material which postdates the Act in order to understand its purpose. And my submission in that regard is that there's now not one but two Supreme Court cases which support the appellant's approach in relation to this interpretative aid, to the extent that the court finds it necessary. And that's the Palestine Solidarity Campaign case. If the court is concerned with this point and would find it helpful for me to dip into it, I propose to go to the case. But if not, then I can just take this at a high level without going to the
You must take your own
authorities.
course, it's your application. If you want us to look at it, it's tab 11 in the authorities one.
Yes. Well, then thank you very much. I will ask the court to turn it up. There's just an extract that has been provided in the bundle. And the court will see on page 197 in the bundle, paragraph 8, just above the indented quote. The guidance that was mentioned in this judgment was put in place in November 2016, meaning that it post-dated by at least a couple of years the statute that was being interpreted. Lord Wilson then undertakes the statutory analysis, and this begins on page 202 at paragraph 23, the application of the principles. And he starts where I've just started, which is with the terms of the Act. And I just note, he also makes a submission that I make, which is that even where there is a broad statutory discretion, that discretion is not unfettered. And I would add, it's a discretion that must be exercised in accordance with the purpose of the Act. So Lord Wilson first looked at the wording of the Act, which we've just done. Then he turned to regulations made under the Act. And then finally, and this is paragraph 25, he turned to the unchallenged parts of the guidance. And he looked at the subject matter and he took out of that guidance the important words which he identified as illuminating the purpose of the Act. And he says at paragraph 26, from these three instruments, so it could not be clearer that he is relying on each of the instruments, the Act itself, the regulations, and the guidance. So that puts paid to the respondent's suggestion that it's only really looking at the legislative stuff, the guidance, I paraphrase, the guidance which is put in place often by the executive is not relevant as an interpretative tool. And that's not right, because plainly here, each of the three instruments was relied on to illuminate the purpose of the Act. And that was essentially what the appellant's submission was in relation to reliance on the guidance and gear change documents that post-dated the Act in order to understand what the purpose of the Act was. The judge, in her judgment, characterised that argument as extending or amending the statutory objective. And in my submission, that is not correct. What the appellant was saying was to understand the purpose of the statutory objective, to understand the purpose of section 16 read with section 18.
There's no duty to publish any guidance.
There's none, indeed.
So what if no guidance was published on active travel? How could this provide any help on understanding the purposes of the statute?
If there was no guidance, then there would be no assistance provided by a non-statutory instrument.
Yeah.
I think possibly part of the point of there being statutory guidance and it being thought by the Supreme Court to be of assistance is because that positive decision has been made to publish guidance, which in our submission illuminates the purpose. Plainly, if there's no guidance, it won't be of assistance. In my submission, though, the appellant's submissions below were correct in drawing some support from the statutory guidance for saying that active travel and direct active network management actions taken in relation to active travel does properly reflect the purpose of the section. And I just stand back to say, because this is also relevant to ground one, that it was never anticipated when this challenge was brought that there would be this kind of pure point of statutory interpretation and a disagreement, really a fundamental disagreement between the appellant and the respondent on what the purpose of the Act is and whether certain things fall within and are reflected in the extent of the network management duty. We had anticipated that that would all be common ground. And this all came to a head, and ground one became ground one because of the pre-action correspondence, where it became clear that the Secretary of State takes a very different view. And in my submission, that ground one and that very different view expressed by the Secretary of State is in and of itself an important reason for the court to grant permission in this case. I immediately accept that it's not every case where there's a disagreement between an appellant and a respondent about the meaning of a statute or its purpose that will reach the threshold. The question is whether, arguably, the interpretation of the statute and its purpose put forward by the appellant is credible. And in my submission, in this case, it is. It is when the full language of the statute is taken into account, and it is when the statutory guidance made under the statute is used as an interpretative tool as it can be. And of course, my submission simply for today's purposes is that that is enough to get over the permission threshold. because it would be very helpful for a court to identify and make clear whether the Secretary of State is indeed correct or whether the appellant is correct in this quite crucial understanding of a wide-ranging duty imposed in relation to a very large proportion of the network of roads in this country. Unless the court has any questions in relation to the interpretative submissions, either the meaning of the Act or its purpose and the meaning of the sections, I'll move on to the revoked statutory guidance. I'm very grateful. The revoked guidance, the court will have seen in the papers, was initially published in May 2020 and updated 5 times thereafter. So it was, and the appellant has never shrunk from this, guidance which began as COVID-related guidance. But each time, each iteration, each update of the statutory guidance took account of the government's evolving policies on active travel and took account of the government's identification of COVID and the response that it required as presenting an opportunity to embed certain network management measures, certain road measures, in order to support active travel. And that
I think it would be right to say that COVID was used quite widely in relation to traffic management to do things that otherwise wouldn't have been done. I mean, I can say that. I can say no, wouldn't have been done. I live in an LTN, and it became an LTN as a result of COVID. Mm-hmm. And then they took away the signs that said this junction's been closed for social distancing purposes, mm-hmm. and it's just closed.
Yes.
They wouldn't have been able to do that, but for COVID. So it has all evolved from COVID. A lot of this has evolved from COVID.
My Lord, if I may just push back gently on that to this extent. In my submission, there's nothing in the papers before the court that evidences that measures like LTNs, or indeed cycle lanes delineated in a particular way, or management around schools, would not have come in at some point later in time if COVID had never occurred.
Well, that's a bit of an unknown.
Indeed.
Anyway.
These were measures that were thought about and considered without COVID having ever been something that we had to deal with. In my submission, where your Lordship is absolutely right, is what happened rapidly in a way which was probably unforeseeable, is that these measures started to be put in place and put in place at scale. Mm. And then effectively, and there's to a certain extent some evidence in relation to this because the statutory guidance makes it clear, effectively what happened was an experiment about the extent to which these types of measures would work or not. And where the guidance ended in April 2022 was that it indicated a number of things. First, and this is from the ministerial forward on page 145, that of course being part of the statutory guidance itself, as Mr. Justice Dove made clear. The forward...
So this is Mr. Shapps's forward.
Yes, Mr. Shapps's forward.
Yeah.
Makes clear that this is his first paragraph. This is his interpretation of the COVID-related aim was to build on and embed the increase in walking and cycling. And then he makes it clear in his paragraph 3, having gone through the transport decarbonisation plan, so linking that to climate impacts, that the additional network management guidance is still an important part of the picture because it's imperative to ensure the objectives in gear change and elsewhere. I've just asked my learned junior to double check. My recollection is that gear change was a policy that was not linked to COVID.
It came out in July 2020.
Yes, but the policy having come out at that point, I think means it must have been in development well before COVID was upon us.
Yeah.
And so the Secretary of State then in his next paragraph makes it clear that this is looking to make significant changes continue, but, and he makes this point, and this is the point I think I just summarised to your Lordship, not every scheme is perfect. A minority, in his view, won't stand the test of time, but schemes need to be given the time, and we need effectively to understand what should stay in place and what shouldn't. So then the network management duty guidance full on begins page 146, the next page. That refers to gear change and refers to making permanent and capitalising on the changes made during the pandemic, and then refers to the reallocation of space and the measures. So this, just going back to the statutory wording of section 18, these are the techniques of network management. They're the beginning of them. So the reallocation of road space measures is set out there in the guidance. There's reference to Active Travel England over the page. And then, sort of in the middle of that next page, 147, the point is made, and this is a point taken against me, so I'll address it briefly, that none of the measures highlighted in the guidance are new. And that also, to a certain extent, my Lord, may address your Lordship's concern that these were creatures of COVID. None of the measures in the guidance were new. And then all of the measures are set out in bullet points. The last bullet point at the bottom, modal filters, that's the only bullet point that deals with low traffic networks. Everything else deals with something very different from a low traffic network. Now, just standing back,
When you say something very different, but the bullet point at the bottom of page 147 is talking about pedestrian and cycle zones.
Yes.
And that's picked up in some of the briefing to ministers as being an example of an LTN.
Yes. I mean, your Lordship, in fact, I would suggest your Lordship's point makes it clearer that the modal filters bullet point is not just even about LTNs. It's about LTNs and other things.
Yeah.
But this is the one bit.
Interrelated.
Well, I don't think I would accept that, my Lord. The LTNs are included in this bullet point because they are a type of modal filter. But modal filters that are focused in particular on pedestrians and cyclists, like, for example, the installing of cycle facilities with a minimum level of physical separation, that's point 1, which is also a modal filter, that can have nothing to do with an LTN.
Yeah, one mustn't read this sort of material like it's a statute, because I notice at the end of that bullet point it's still talking about social distancing.
Yes.
A hangover.
Yes, and we've never shrunk from the fact that this guidance had its birth into the world in COVID. Yeah. And a lot of what it said referenced things that happened in COVID and were relevant to social distancing. And that language didn't disappear from the guidance, even though, and I think I can make this submission quite strongly at permission stage, it is clearly arguable that the obvious intention of this guidance was no longer to be COVID guidance, but was to be, and this is the name change, network management to support active travel guidance. It shuffled off its COVID coil when it became this guidance, at least arguably for this stage. But in my submission, it is very clear when one looks at the way that this guidance developed over time and all the statements around the guidance about embedding policies, for example, like gear change. So that, so far as the bullet points are concerned, and then of course there's the bit at the bottom after all the bullet points about the potential to encourage walking and improving public spaces through permanently retained footways. That doesn't make it into the bullet point, but that is also one of the methods. Then there's monitoring and evaluation, and I won't go through it in any detail. There's the potential for certain types of traffic order to be used under other considerations, and then there's engagement and consultation. And that part, if the court has had that part changed very considerably once COVID was no longer a consideration, because there was obviously very little opportunity for engagement during COVID, but this is a very different section in light of the embedding of this after COVID. So that is the approach that's taken in the guidance.
Are you leading the guidance?
I'm leaving this...
Could I ask one question?
Yes, please.
You introduced from the statute, section 16, reference to management techniques.
Yes.
And when we got to the 9 measures, you said these were the management techniques you had in mind. But if I follow, the reason why you see this guidance as being so important to your argument is because these are all examples of the reallocation of road space, the terminology used in the guidance.
Partly that's right.
And reallocation of road space refers to reallocating road space from vehicles to pedestrians and cyclists. That's what the 9 measures are all about.
Yes, because the focus of this guidance is on the 2 other elements.
So if we're looking to see what you take on your approach to statutory interpretation, if we look to see how we have to understand the 2024 Act, one of the objectives you read in is reallocation of road space.
The objective of securing, let me get the exact wording so I'm not saying something that is not right to the court. The objective of securing the expeditious movement of traffic, which we know is not just cars but is pedestrians and cyclists, is understood in relation to what the techniques of network management are, to include, not only, but to include this type of reallocation of road space to pedestrians and cyclists.
That's what I thought.
I'm very grateful. And the reason that this guidance focuses on those techniques was that the previous guidance, the 2004 guidance, focused on techniques that are specific to cars. And if I can just turn that up very quickly to make good the point. That guidance is in the supplementary bundle at page 5. And the court will see in this guidance, well, if I could first start with something that isn't there, it doesn't refer to the phrase active travel. It only refers, and this is in paragraph 38, it only refers to the desire to make cycling and walking safer and more attractive, and that not being seen as in conflict with the principles of the duty. So, as at 2004, when one was looking at all 3 of the obligatory elements of the network management duty, cars, pedestrians, I say cars, I mean motorised vehicles, pedestrians and cyclists, all 3 of them. As at 2004, the guidance said only this in relation to what has now been understood and characterised as active travel. It talks generally about the desire to make cycling and walking safer and more attractive. And of course, the techniques that your lordship has just mentioned in terms of apportioning parts of the road to different users are techniques of making cycling and walking safer and more attractive. But the detail of these traffic management techniques, network management techniques, is not to be found in the 2004 guidance anywhere. It is only in the revoked statutory guidance. The 2004 guidance, in as much as it touches on the reallocation of road space, that's on page 14 of the bundle. paragraph 51, takes it at a very high level. And this is the sort of third line down. The guidance makes clear that it's for the local authority to decide the levels of priority given to different road users. That, of course, remains the same. It makes it clear that priority may be given to one over another on certain roads through the reallocation of road space. So the 2004 guidance does not shrink from making it clear that there's a potential for reallocation of road space, but it doesn't set out any of the management techniques that fall under pedestrians and cyclists. What this 2004 guidance focuses on is motorised vehicles. And so while it's right, and the guidance, the revoked guidance makes it clear that none of the techniques of network management were new, what was very new was the inclusion of them within this guidance and the resulting requirement for local authorities when undertaking their network management duty to have regard to these techniques. Because this, of course, is statutory guidance. It has a potentially quite significant impact on the way that a local authority understands its duty. Because if the authority is not going to follow the techniques or employ the techniques in this guidance, then it has to explain why. And that's a very, very different position from that in 2004. Plus, of course, in 2004, there was a very different overarching statutory context, because there wasn't a Climate Change Act, there wasn't a net zero obligation, there weren't air quality targets, there wasn't an environmental improvement plan, there weren't regulations about particulate matter. None of that background set of statutory interlinking obligations, which, and I don't think the Secretary of State disagrees with this point, all of which give more impetus to active travel. None of that was in place. But it was all in place and was all in the minds, essentially, of the guidance, the revoked guidance, when it was dealing with active travel measures.
Just taking climate change, where's that dealt with in the 2022 guidance? Please?
So that's the reference to the Transport Decarbonisation Plan.
That's what I wondered. That's the only reference?
Yes.
Yeah. And where's air quality referred to?
I do have references in relation to
Well,
that.
we'll come back to it.
I might come back to it.
Thank you.
Thank you very much. But I don't think, my Lord, certainly at this permission stage, that any disagreement has arisen between the appellant and the Secretary of State that this guidance was aimed, at least partly, in dealing with things like air quality and climate change. There was no disagreement between the parties on that. So, if I may then turn to how the guidance, the statutory guidance, 2023 decision was made to withdraw it, unless there are any other questions about the two.
Yeah, your third heading, yeah.
I'm very grateful. So the decision to withdraw the statutory guidance, to the extent that we have evidence of it, the court has already seen it on page 142, that was made on the 12th of September 2023. And there were 4 sets of ministerial submissions in the run-up to that decision. And all of that material is in the supplementary bundle from page 30 onwards. Forgive me, from page 50 onwards. Oh my goodness. I'll get there in a minute, forgive me. From page 36 onwards. My apologies. And all of this background material came as a result of the pre-action correspondence between the parties. So the court sees that there was in September 23 a kind of overarching set of documents put together, referred to in August of that year, with a number of annexures. And it's working the way through those annexures that shows the chronology of what happened. So on page 38, one sees the 31st of August 2023 review of LTNs. And that identified that the focus of the approval that was being sought was in relation to the planned LTN review. And agreement was being sought on a number of things, including that officials should write to local authorities, as in Annex A, which we'll look at in a second. And the second thing was agreement to remove the supplementary network management duty guidance for local authorities. And that is dealt with in some more detail at paragraph 9 on the next page, page 39. And that refers back to earlier advice, which suggests the withdrawal of the guidance. This makes the point the guidance was first issued at the height of the pandemic and revised in 2022. And it contains, including in its references to LTNs, what is described as what now feels dated and no longer in line with ministerial priorities. We would look to replace it in due course with new guidance shaped by the outcome of the LTN review. So just pausing there, and this is a point I'll make generally about these documents. And it's a point I make generally about these documents, having made the point below, and the Secretary of State having been asked where in the documents the thing I'm about to say happens, and not being able to point to it. One sees here in this paragraph the references to LTNs, but including LTNs first. But in my submission, nowhere in any of these documents that were put before the Minister is any of the other network management techniques that we looked at together a moment ago, are any of those other techniques brought to the attention of the Secretary of State. Nor is it brought to the attention of the Secretary of State that those are techniques which further not just active travel, so cycling and walking, but they also further the transport decarbonisation plan, they also further air quality targets being met. Nowhere in any of these submissions is that mentioned. So while there are, as the judge picked out in her judgment, broad references, wording like including, the only measure that is brought to the Secretary of State's attention, and the only measure that is the focus of the political concern, and the only measure that is sought to be done away with, is LTNs. And one sees that, again, further on in the document, page 42, Annex C. This was a note to number 10, again on reviewing LTNs. Over the page, paragraph 5 and 6, one sees the same thing said there as was said in the later document, originally published into the 2020 supplementary guidance was published during COVID to enable the rapid rollout. LTNs are cited as one of the measures. And then next, removal will send a clear message that things have changed. But just standing back, of course, the things that have changed do not include gear change and the support for cycling and the support for move to
Well, there has
active
been a
travel.
change to gear change. Some of the paragraphs have been withdrawn.
but certainly not all of them, and certainly not the paragraphs.
It's not right to say it's not been changed.
Well, your Lordship is entirely right. The change that happened to the gear change document, was not the wholesale lack of support or removal of support for active travel measures.
No.
Certain things. And your Lordship, in fact, makes a point that I made to the judge below, which is, and it goes to the disproportionality aspect of irrationality. The impetus here being concern about and removal in relation to LTNs. There was an obvious way that the network management guidance could have been amended to remove any reference to LTNs as a network management tool that local authorities should take into account. That would have been just as easy and would have sent a message about LTNs. But what happened was not that. What happened was, in the absence of the Secretary of State being told anything about the network management techniques to do with cycling and pedestrians that weren't related to LTNs, or being told anything about the broader climate and air quality and purposes of active travel, the entirety of the guidance was removed, at a stroke removing the only guidance that goes into detail about techniques of network management relating to active travel. The earliest document, and given that they're in the bundle in this order, that's why I've sort of gone backwards in time rather than forwards in time, is the 17th of April 2023 document. That is the document at page 50. And this is where we get a reference to gear change commitments. And here, paragraph 8 makes your Lordship's point that there are a small number of commitments which no longer feel appropriate, and those were proposed to be removed to allow continued focus on the core elements of the plan. So a very different approach taken in relation to gear change, but the statutory guidance, which is the only guidance that has these techniques of network management in it in relation to walking and cycling, was removed wholesale. And one of the reasons that this statutory guidance was removed wholesale was that it was identified as one of the small areas where the government could, in fact, take steps. It was made clear to the Secretary of State that because of the way in which essentially the local authority road traffic network powers are structured, there was very little that could be done other than remove this guidance. And in my submission, that's relevant to both the rationality ground and to the improper purpose ground. It's, in my submission, unusual to have it made so plain in writing to the Secretary of State. It's unusual to have it made so clear in writing to the Secretary of State that there's not much that can be done, and if you're looking for a way to do something, the removal of the guidance is really the best and only way that is available. Because that is direct evidence of the reason for the removal of the guidance, being focused on the political concern around LTNs. Now, I say immediately, and I said this below as well, the government obviously is entitled to have its political concerns, obviously is entitled to shape its guidance however it wishes. But in circumstances where those concerns are narrow and focus on one thing, it is in my submission correct as a matter of law that the exercise of the discretion, particularly when we're dealing with a statute that has a particular statutory purpose, that the exercise of the discretion is such that it does not go further than the reason that is being given, and it does not go so far as to undermine the purpose of the Act. And in my submission, it's at very least arguable that that is what has happened here. My apologies. There was one further reference that I had just lost that I wanted to draw the court's attention to. Yes. My apologies. It's paragraph 1, and my gratitude.
Paragraph 1 of?
Paragraph 1 of Annex C on page 42. I've taken you to the document, but omitted this reference.
Back to 42.
Back to 42. My apologies.
That's right. Just get the page right.
Yes, 42.
Yeah, 42, yeah.
Paragraph 1. This is the note to number 10 on reviewing LTNs. And this makes good with the submissions I've just been making. Ministers have limited tools for intervening in local authority schemes. Legal powers do exist, but the bar is very high. Not to our knowledge ever exercised. In view of that, they focused on the approach that removes existing guidance immediately, and this is why there was immediate revocation, and ensures that high standards apply to the schemes going forward, however they're funded, and putting pressure on local authorities to act. So, and there are other references, that this is just one of them. So in my submission, it is plain why this guidance was alighted on. It was in relation to LTNs. And it is plain why the guidance was sought to be removed immediately. It was in order to address the concern around LTNs. So,
really making the point I made to you at the outset, that there was a concern about LTNs because they'd been introduced during COVID without consultation, and there was, in some areas, concern by the residents that they didn't want it.
yes.
And that looks to be reflected in the bullet points.
Yes.
I should say, I think my LTN is widely regarded as a success. I should tell you that. But that you can see that that's what the concern was.
Yes.
In those bits. Your point is that that was one, and you say narrow reason, and shouldn't have resulted in the withdrawal of the entirety of the guidance.
My lord, yes.
Yeah, I'm sorry.
Because there are many other management techniques in the guidance that are unrelated to LTNs,
Yeah.
and that are closely related to the bits of gear change and other statutory elements that remained fully part of the government's commitment.
Yeah.
So if I may then turn to the particular grounds.
Yeah.
So ground 1 of the judicial review challenge was that the decision and the resultant impact frustrated the legislative purpose. So I've already addressed that in quite some detail to the court about what the legislative purpose is, and we say the judge erred in that regard in looking narrowly at what the legislative purpose was and failing to understand the crucial element of it being a network management purpose with a particular goal in mind. And that the judge erred in not taking into account the statutory guidance as an indicator of what that purpose was, and erred in not finding, or in finding positively, that the withdrawal of the network management guidance didn't, at least arguably, undermine part of, because of course we don't have to say the whole purpose of the Act is undermined by this, part of the purpose of the Act is undermined. That part that relates to pedestrians and cyclists, all three of which are, of course, the movement of traffic. Now, there were a few things to which the judge referred. She referred to submissions by counsel for the Secretary of State that new guidance would be developed, and in our submission, that was an irrelevance, and it led the judge to go wrong the intention of the future government isn't relevant to the decision that is under challenge, and it isn't an answer to the appellant's arguments about a lacuna being created, both when the challenge was brought and indeed now, indeed still presently, by the removal of the statutory guidance, and that lacuna in practice thwarting the objectives of the statute. Third, the judge made the point that there wasn't this active travel guidance before 2020. And in my submission, that is not fatal to the appellant's ground, nor does it mean that the ground is not arguable, simply because there was a period of time over which the understanding of the network management techniques relating to pedestrians and cyclists developed does not undermine in any way the purpose of the Act being for those techniques to be employed to the extent that they can to achieve the expeditious movement of traffic alongside the other obligations of local authorities. So that, in our submission, decontextualises matters and is effectively a non sequitur. The respondent responds by saying that the judge was entitled to have regard to the fact that the power to issue the guidance was discretionary, and it had previously been exercised in that discretion not to have the guidance in place. But in my submission, that point doesn't take the argument any further, because it doesn't grapple with and address the fact that the guidance was put in place and did very fundamentally change the position for well-established techniques, but which had never been put in the guidance before. And I've already addressed the court on the arguable case in relation to the fact that the parties disagree on the meaning and the objective of the legislation. So, my lord and my lady, unless there's anything else on ground one,
No.
I'm grateful. Ground two looks at material considerations. And the overarching submission is that there were a number of obvious material considerations which should have been brought to the Secretary of State's attention and which should have been in the Secretary of State's mind, but which the documents evidence were not. The first of those, and these were effectively ignored by the judge because they're not mentioned at all in her judgment, was the failure to take into account the wider climate and air quality policy considerations that informed, for example, the Transport Decarbonisation Plan and the link with active travel. It cannot be assumed, without evidence from the documents that were put before the Secretary of State, that the Secretary of State was aware of any of that. It is not referred to in any of the documents that was put before the Secretary of State, and it is not referred to in any of the Secretary of State's own explanation given to Parliament or elsewhere, but mainly we have the explanation given to Parliament because there's no other written decision about why this guidance was being withdrawn.
Sorry, I don't follow that. What you mean? There was no express reference to it?
That's an indicator, my lord, that the Secretary of State was unaware.
Yeah, I follow that. You've got to say that by reference to the fact that there was no express reference.
Correct.
You're
making the assumption that the Secretary of State withdrew guidance without actually looking at what the guidance said.
Yes. And that's because the whole point of the ministerial submissions is to draw to the minister's attention the matters material to the minister's decision. And it is for the Secretary of State to show, because this is a key question when a minister withdraws or takes this kind of action. It's what the minister knew personally. It's not what his officials knew, it's what the minister knew personally. And in this case, differently from other cases where you can't make this submission because it's obvious that something was read, in this case, the Secretary of State has continually failed to be able to show evidence that the minister personally was aware of these things. And again, at this stage, all I have to show is that this is an arguable point. There's no knockout blow. Had there been, the Secretary of State would have provided it. Instead, what the Secretary of State said is, wrongly, that the Secretary of State should be assumed to be aware. And that, in my submission, is not right.
You are, of course, aware of what is in the summary grounds of resistance filed by the Secretary of State, accompanied by a statement of truth, referred to by the judge in her judgment, paragraph 35, because that refers to earlier briefing to the Minister in March.
My Lord, yes.
And that specifically refers to building in and embedding increases in walking and cycling, and refers to measures for reallocation of road space to people walking and cycling. That is a succinct summary of what the guidance was doing, and that goes to the nub of your case.
Well, we certainly didn't have any disclosure of that.
Did you ever ask for it?
I will have to double check. I'm sure that double checking will happen.
I mean, to be fair to you, the judge says in her judgment it wasn't in the bundle before the High Court, but then that's down to the parties.
Ah, yes, this is the paragraph about concerns in relation to 15-minute cities.
Well, it starts off with that, but I've read it as a whole. Paragraph 35, page 95 of the bundle.
Yes.
It's the second bullet point under paragraph 7.
Oh. Yes. My Lord, yes. And in my submission, it is telling, well, first of all, that doesn't bring to the Secretary of State's attention the link that I was making, and that, as I understand it, has been accepted between active travel, climate objectives, and air quality objectives. It also does not bring to the Secretary of State's attention any of the detail in relation to the techniques about reallocation of road space to people walking and cycling. And in my submission, in the context of a briefing document, which first is concerned about 15-minute cities, and then latterly, where none of that information, that detail is provided, is about low traffic networks, one would forgive the Secretary of State for understanding those techniques to be about 15-minute cities and low traffic neighbourhoods, low traffic networks.
So that really does go to the point that he didn't look at his own guidance.
Yes.
You have to say that.
Yes, I have to say that.
I mean, that's the submission.
Yes.
Yeah.
Yes.
Even though his attention is strictly is specifically drawn to it, in the documents referred to in paragraph 35.
Yes. Well, if the minister had read very carefully the guidance and had fed that into his decision making, no doubt that would have appeared in the summary grounds for the statement of truth. But it doesn't. It has never been said on behalf of the Secretary of State. Ever. And again, at permission stage, that's effectively the point. Had there been that knockout blow, one would have anticipated it to be landed, but it didn't. That to material considerations. There are other minor points, but in the interest of time, if I may, unless there are other questions, move on to ulterior purpose and disproportionality.
Which is ground 4.
Ground 3. Ground 4. Well,
Original ground 4.
Sorry.
yes.
Ground.
Yes. Forgive me. Yes.
Sorry?
Original ground. Yes. Original ground 4. Appeal ground 3.
Yeah.
Yes, because original judicial review ground 3 went
Yeah.
when the information that we had sought about the LTN review was provided.
Yeah.
So first to ulterior purpose. And I've effectively made this point to the court, that the purpose in relation to LTNs was unrelated to achieving the statutory purpose of the network management duty in relation to cycling and walking and the providing of network management techniques in that regard, because everything was withdrawn rather than just the thing about which there was concern.
But this is based on the statutory purpose.
And this is based on the statutory purpose.
So it's linked to ground 1.
It's linked to ground 1.
Depends on ground 1.
It's linked to ground 1 to the extent that if there's an ulterior purpose, it will only be ulterior if it's, not the actual, if it's not a proper purpose.
Yeah.
Sorry. Yeah, forgive me for saying such a... Yes, I'm grateful. And so we do rely here on Padfield and the exercise of discretion to be used to promote the policy and objects of the Act. And that's why this is linked to ground 1. Separate from ground 1, but more linked to ground 4, it's always difficult to categorise grounds in a judicial review. But the second element is the disproportionality element.
Yeah.
And this was rejected by the judge on the basis that proportionality or disproportionality is not a freestanding public law ground of challenge, but we had never suggested that it was or should be. We had always positioned this ground in relation to the wider rationality element recognised in the Law Society case, which supports the proposition that proportionality, which emphasises that if something is disproportionate, that can be relied on in relation to rationality or unreasonableness. And the part of Law Society, and I do have an eye on the time, but given that Law Society is both grounds, appeal grounds 3 and grounds 4, it might be helpful to go to it.
Paragraph 98.
I was going to go to paragraph, a slightly later paragraph, but we can start at
Well,
paragraph.
it starts there.
We can start at
Well, if you
paragraph.
can go to the later one then.
If I could get to the page first, it would be super helpful. There we go. So yes, it starts on page 157, irrationality, and begins with Wensbury, but then goes on at paragraphs 110 to 115, under the heading, was the policy disproportionate, to analyse the proportionality of what was done in the Law Society case and come to a conclusion as to whether that was an indicator of unreasonableness or not. I summarise. And this recognises in my submission proportionality as an inherent indicator of unreasonableness. The court will have seen, and I don't propose to go to them, but in light of the judge's decision, further analysis of the cases was undertaken, and 2 further cases were put into the bundle, Brind or Brynd and the McGrath cases, both of which in our submission support the point that proportionality is an indicator in relation to unreasonableness. But focusing on Law Society, the Secretary of State's response is, well, in the Law Society case, there was a requirement for a certain amount of detailed scrutiny of the evidence that underlay what happened, and really the disproportionality element goes to that aspect of effectively a higher method of scrutiny. And in my submission, that's not right. All the parts of Law Society that are about more detailed or more anxious scrutiny are the other parts of the Law Society case. They are not under this bit of the heading in relation to was the policy disproportionate and the analysis of proportionality and its interlinking with rationality. But standing back from all of that, in my submission, it is an arguable proposition to put forward that if the intention was to achieve an outcome where LTNs were not or no longer given support or priority, the withdrawal of the network management guidance, which dealt with so much more than just LTNs, was not rationally linked to that purpose. And again, this is against the background of there still being support for those broader other purposes. So then moving on to irrationality in general, and the court will have seen that in the way that this ground was put to this court, there was reliance placed on, in the supplementary skeleton, on the KP Secretary of State versus Secretary of State for Foreign, Commonwealth and Development Affairs. But there was also in the supplementary skeleton, so this is on page 2 of the supplementary skeleton, reliance placed on what was said about the Law Society case in Finch. That was a point that was made below. Just to address the point of Law Society not being specific to its facts, but saying something more general about rationality. And then further reliance is put on KP as drawing on Law Society, describing the particular elements of rationality there, process rationality, requiring the decision maker to have regard to all the mandatorily relevant considerations and no irrelevant ones, but not limited to that. It also goes to a logical error or critical gap. And in my submission, in this case, there is a logical error or critical gap, and it's one we haven't addressed, and I'll just address it very briefly, which is that the ministerial submissions repeatedly describe the guidance as being dated or being a response to the COVID pandemic, simpliciter, not with any nuance. And then the minister, in his statement to Parliament, stated that this was withdrawing COVID-era guidance. And in my submission, for permission stage purposes, it is arguable that that disclosed a material error. Because, as we said at the very outset, while the guidance most assuredly began in COVID, it did not end its life as just COVID-era guidance, as though it had no relevance beyond the COVID era.
That isn't the meaning of COVID-era guidance. you call something COVID era guidance, it's guidance that originated from COVID, which is what this did.
It is, though, the meaning of guidance being dated because it is COVID era guidance.
To some extent, you can see why that shorthand was used, because the 2022 guidance sought to embed measures which had already, on a permanent basis, measures which had already been undertaken during COVID.
Yes.
So it's just shorthand.
My Lord, in my submission, it is at least arguable, given, and we didn't look at them in a lot of detail in this regard, but given the ministerial submissions that were put before the minister, which emphasised repeatedly, not just that this was guidance which began in COVID but then developed into something more permanent, but that this was dated COVID era guidance. Now, my learned friend says, well, that and the judge indeed said, well, that puts a lot of emphasis on the word dated. And I don't shrink from that. I think the word bears that emphasis. It means what it says. And it's an indication to the Secretary of State that this guidance is outdated. But of course it was not. It had specifically been updated to go beyond it.
Some of it was. That's the difficulty. Some of it was dated. I mean, the bits that bang on about social distancing were dated by 2023.
Yes, but that's why previously the ground addressed the fact that the entirety of the guidance was removed, not just LTAs.
That's a separate point.
And not just...
Here we're just on the very narrow point of the descriptions that were given of it. COVID era guidance and dated. And you say, well, that means it's outdated. And it was, because, for instance, it kept talking about social distancing.
My Lord, yes. I made the point that it didn't just deal with that.
No, I follow that point.
Yes, and if the minister was concerned that this was dated COVID era guidance, then the wholesale withdrawal of the stuff that was up to date doesn't follow from that. And that's the serious logical or methodological, logical flaw. That's the logical flaw. Your Lordship has, in fact, very much assisted me to articulate that. That's the logical flaw. That even if the Secretary of State thought that there were bits of the guidance that was dated, there is a very significant logical flaw between that and taking away the only network management guidance which has these techniques to do with active travel for pedestrians and cyclists. Unless the court has anything further.
No, thank you very much,
Very
Mr.
good.
Hon. We will rise for a few minutes.
Court rise able to.
I love your optimism.
What?
That's clearly what you're interested in. Okay. Yeah, so okay, solved. Yeah. You really want it. No. It was very furious. Yeah, it was a habitats case originally. It was fun. I did. Yeah, I did think you said something. Yeah. All right. I'm going to Oxford because my first British tech because I launched it in Oxford. It just kind of well, actually, I've been far away from South Africa. Duncan is turning 80. Well, he turned 80, really. He turned 80 on Tuesday. So we're having a party. Oh my gosh, this is wonderful. Yeah. It's really beautiful. So we'll do some walking. And then we'll go to a park in the countryside. And some really nice. That's fun. I'm not going to think about a single thing other than that. Hope you only going to be knee deep in 750,000 pages of books.
Yeah.
Yes. Yes. Yeah. I mean, I don't have, I'm involved, but peripherally in quite a big data protection. And I suppose I see the value being added because these amazing documents appear, which summarize things, tell me where things are, and I get, I stuff brought to my attention, and it's really taken hours of just told it. So I see value. Yeah, no, God. You have been. What in July? Spent Where? Oh, Alba. Wait. That's in the day, though. Yeah. Yeah. Oh.
Where else?
That's wonderful. No, they don't. No, it will not be like that.
Friday.
Yeah, I have.
Oh, yeah.
Yeah.
See you then.
Got some friends from
Oh, great.
two or three.
What riding are you doing?
Mr. Ormondroyd, we don't need to hear from you. Thank you very much. Thank you very much, Mr. Hon. I will ask Lord Justice Holgate to give the first judgment.
The appellant appeals against the decision of Mrs. Justice Heather Williams on the 7th November 2024, refusing permission to apply for judicial review and ordering him to pay the respondent's costs of preparing her acknowledgement of service. The challenge is to the Secretary of State's decision of the 2nd of October 2023 to withdraw guidance entitled, quotes, Traffic Management Act 2004, 2004, network management to support active travel, close quotes, which was issued under Section 18 of the Traffic Management Act 2004, in brackets, quotes, TMA 2004, close quotes, in brackets. Quotes, active travel, close quotes, refers to cycling and walking. Permission to apply for judicial review had previously been refused on the papers by Mrs. Justice Lang on the 29th of May 2024. Part 2 of the TMA 2004 deals with the management by a local traffic authority or a strategic highways company, open brackets, e.g. Highways England, under the Infrastructure Act 2015, close brackets, of its road network. These bodies are referred to as network management authorities. Section 16 sets out, quotes, the network management duty, close quotes, indent, and I asked to read into the transcript the entirety of section 16, end of indent. Thus, the objectives are focused on the expeditious movement of traffic on the road network. Quotes, traffic, close quotes, includes pedestrians, brackets, section 31, close brackets, and, comma, there is no dispute, comma, cyclists. Section 17, subsection 1, requires an authority to make such arrangements as they consider appropriate for planning and carrying out the action to be taken in performing its duty under section 16. Those arrangements must include processes to ensure, brackets, as far as reasonably practicable, close brackets, the identification of causes, actual or potential, of road congestion or other disruption to traffic, and possible action in response thereto, brackets, section 17, subsection 4, close brackets. The arrangements must provide for specific policies or objectives for different roads or types of road and for monitoring and assessment of management performance. The TMA 2004 imposes the duties in sections 16 and 17 on traffic management authorities. There may be competing demands for the use of road space. Public funds are finite. Individual authorities may set priorities and make choices. They may balance the considerations as between different modes of transport. Section 18 provides indent and open quotes, and I asked to read into the transcript the whole of section 18, end of quotes and indent. The appropriate national authorities are the Secretary of State in England and the National Assembly for Wales in Wales. Thus, the respondent is under no obligation to issue any section 18 guidance, whether on any particular subject, such as active travel, or at all. But where guidance is issued, Section 18, subsection 2 requires management authorities to have regard to it in performing their duties under Sections 16 and 17. The TMA 2004 makes no further reference to Section 18 guidance. Section 19 enables the respondent to require a network management authority to provide information connected with the performance of their duties under Sections 16 and 17. Sections 20 to 30 deal with the enforcement of those duties by way of inter alia intervention notices and orders, brackets with the appointment of a traffic director, close brackets, given by the Secretary of State. The first and now only Section 18 guidance is the respondent's quotes, Traffic Management Act 2004, Network Management Duty Guidance, close quotes, issued in November 2004, open brackets, quotes, the 2004 guidance, close quotes and brackets. The foreword states that network management is one element of an authority's transport functions and should complement other policies and actions, including local transport plans. The document gives general guidance on the scope of the duty, main considerations, wider responsibilities, principles of network management, and good practice on techniques and approach. Under the network management duty, local traffic authorities have to take account of the needs of all road users, managing the road space for everyone, which will involve setting priorities and making choices. Open brackets, paras 17 and 26, close brackets. The network management duty is not at the expense of an authority's other duties and objectives, open brackets, paragraph 34, close brackets. Quotes, safety and environmental considerations remain important, close quotes. The expeditious movement of traffic should be safe for all road users, particularly pedestrians, cyclists and motorcyclists. An authority also needs to consider its other responsibilities, such as those under environmental protection legislation and planning legislation, open brackets, para 36, close brackets. It is for the authority to decide on the most appropriate approach for managing demand on its own network. This includes making cycling and walking safer and more attractive, open brackets, paragraph 38, close brackets. Although the duties in sections 16 and 17 are the same for all authorities, the issues each faces may differ, open brackets, para 48, close brackets. Authorities should have a clear understanding of the needs of different road users and have balanced policies for addressing them. It is for the authority to determine the level of priority given to different road users on each road, open brackets, para 51, close brackets. On the 9th of May 2020, the respondent published supplementary section 18 guidance entitled open quotes, Traffic Management Act 2004, Network Management in Response to COVID-19, close quotes. This guidance was updated in May and November 2020 and January and July 2021, leading to the final version, brackets, with its altered title, close brackets, dated the 1st of April 2022, open brackets and quotes, the 2022 guidance, close quotes and brackets. It was this version which was withdrawn on the 2nd of October 2023. These versions were all said to be additional to the 2004 guidance. In his foreword to the 2022 guidance, the then Secretary of State said this, and colon indent open quotes, and I asked to read into the transcript the following quotation, starting with the words, "This additional guidance was originally published," and ending 4 paragraphs later with the words, "and to maintain the changes they have already made," end quotes and indent. The 2022 guidance is a relatively short document. It states that it sets out, quotes, high-level principles to help local authorities to manage their roads and what actions they should take, close quotes. The 2022 guidance referred to a number of other government policy documents, including, quotes, gear change, comma, a bold vision for cycling and walking, close quotes, brackets, published in July 2020, close brackets, and the Transport Decarbonisation Plan, brackets, published on the 14th of July 2021, close brackets. It also referred to official advice on the provision and design of infrastructure such as Local Transport Note 1/20 cycle infrastructure design, open brackets, quotes, LTN 1/20 close quotes, brackets, and Manual for Streets 1 and 2. The guidance also referred to the forthcoming establishment of Active Travel England, open brackets, quotes, ATE in capitals, close quotes and brackets, in August 2022, close brackets, the department's agency responsible for allocating funds for active travel schemes across the country. In addition, in July 2022, the respondent had adopted her second cycling and walking investment strategy under Section 21 of the Infrastructure Act 2015. The following section of the 2022 guidance is important to the issues in this case. Indent, open quotes. And I asked to read into the transcript the entirety of the section headed with the words reallocating road space, measures, through to the end of that section, which ends with the words, the potential to encourage walking and improve public spaces through permanently retaining footways widened to permit social distancing should be carefully considered, end quotation and indent. The 9 bullet points in this extract from the guidance, from the 2022 guidance, have been referred to as, quotes, the 9 measures, close quotes. Although the 2022 guidance has been withdrawn, the other policies and guidance to which it referred, such as gear change, the Transport Decarbonisation Plan, LTN 1/20, and Manual for Streets, remained in place, brackets, although some parts of gear change were also withdrawn, close brackets. In addition, the guidance on 20 miles per hour speed limits continues to be replicated in DFT Circular 01/2013, brackets, see the summary grounds of resistance, close brackets. The remainder of the 2022 guidance cross-referred to guidance in LTN 1/20 on monitoring, evaluation, engagement with users and consultation. It also summarised legislation for the making of traffic regulation orders. To summarise, the 2022 guidance was high level and short and relied substantially on cross-references to other documents which continued to apply after it had been withdrawn. The focus of this proposed challenge by way of judicial review is to the section headed reallocating road space, which I have quoted. The evidence on the decision-making process leading to the withdrawal of the 2022 guidance covers the period from about March 2023 to the 3rd of October 2023. I deal with this under ground 2 of the proposed judicial review. The appellant's statement of facts and grounds initially raised 5 grounds of challenge. At the hearing before the judge, Ms. Estelle de Hon, King's counsel, who together with Ms. Jessica van der Meer appeared for the appellant, withdrew ground 3. The judge decided that the remaining grounds were unarguable. The appellant does not pursue ground 5 in this appeal. We are left with grounds 1, 2 and 4 in the proposed judicial review. Ground of appeal 1 relates to the first ground for judicial review. Grounds 2 and 3 relate to the second ground, and ground 4 to the fourth ground. I shall refer to the grounds in the claim for judicial review. Cross-heading, ground 1 of the judicial review. At the hearing before the judge, Mr. Hon also abandoned paragraph 36 of the statement of facts and grounds. The appellant submits that the decision to withdraw the 2022 guidance undermined or thwarted an objective of the TMA 2004 and so is unlawful. That objective, it is said, is to ensure that roads accommodate active travel and that such changes are made to roads as will secure and increase active travel, brackets see paragraph 35 of the Statement of Facts and Grounds and paragraph 16 of the appellant's skeleton, close brackets. The respondent's decision, quotes, removes a key part of the statutory framework for active travel and leaves a lacuna, close quotes. The 2004 guidance does not address targets such as active travel, transport sector decarbonisation targets, statutory air quality targets, the net zero target, and the 2028 particulate targets. The appellant's argument is misconceived. The objectives of the TMA 2004, in particular sections 16 to 18, are to be found in the language used by Parliament. There is nothing in the statute to indicate a statutory objective of requiring or even encouraging measures to secure or to increase walking and cycling, or for that matter, any mode of travel. The objectives in the TMA 2004 of securing the expeditious movement of traffic and related provisions are not expressed so as to enhance or prefer any particular mode of travel. Furthermore, the TMA 2004 does not require any Section 18 guidance to be produced whether to address the matters which the appellant alleges have fallen into a lacuna, or indeed at all. The publication of the 2022 guidance simply involved the exercise by the Secretary of State of a discretionary power. It does not follow from the fact that that discretion was exercised by including a policy that supports retention of existing and the promotion of additional active transport schemes as a reallocation of road space, that as a matter of law that policy is to be treated as an objective of the TMA 2024. That is a non sequitur. The simple point is that there was nothing in the Act which required such a policy to be introduced as Section 18 guidance in the first place. The authorities cited by the appellant, in particular the Queen brackets Palestine Solidarity Campaign Limited close brackets, against Secretary of State for Communities and Local Government, 2020 UKSC 16, colon 2021 Weekly Law Report 1774 at 26, and for Women Scotland Limited against Scottish Ministers, 2025 UKSC 16, colon 2025 2 Weekly Law Report at 8 to 11, do not provide any support at all for this fallacious approach to statutory interpretation. The Palestine Solidarity Campaign case was simply a case where the primary and secondary legislation, as well as the guidance issued thereunder, were all saying the same thing as regards the objectives of the legislation. Any guidance issued under Section 18 of the TMA, I'll start that sentence again. Guidance issued under Section 18 of the TMA 2004 may be issued from time to time, and of course it may change. The statutory purposes of Sections 16 to 18 of the 2004 Act do not change according to changes in such guidance. I would also add for completeness that the appellant has not made out an arguable case on the facts that the withdrawal of the 2022 guidance has left a policy lacuna in any event, as is apparent from the document itself, as well as from the summary grounds of resistance. Much of the guidance cross-referred to other policies and guidance dealing with active travel and other subjects, which continued to apply. Indeed, because of those cross-references, the 2022 guidance did not itself deal specifically with subjects such as climate change and air quality, nor, for example, in relation to the 9 active transport measures. Accordingly, I agree with the essential reasoning given by the judge for her conclusion that ground 1 is unarguable. Cross-heading ground 2 of the judicial review. In summary, the statement of facts and grounds raised 3 issues which the judge accurately distilled in her judgment at paragraph 48, colon, indent, Roman 1. It was disproportionate for the whole of the 2022 guidance relating to active travel to be removed for reasons that related only to low traffic neighbourhood schemes, brackets, quotes, LTN schemes, close quotes, and brackets. It was only necessary to withdraw the LTN part of the guidance. Roman 2. The respondent failed to have regard to the wider role of the 2022 guidance in, quotes, embedding active travel measures, close quotes, addressing climate change and improving air quality. Roman 3. The respondent's decision was taken for an improper purpose, unrelated to the statutory purpose. The LTN reason could not itself accord with the statutory purpose relating to active travel more widely, open brackets C ground 1, close brackets, or provide a lawful basis for the wholesale removal of the wider guidance on active travel. It will be seen straight away, end of quote, end of indent. It will be seen straight away that point 3 depends upon the appellant's contentions on statutory purpose, on the statutory purpose of the legislation under ground 1, which I have concluded already are misconceived. These 3 points have been reordered in the appellant's 2 skeletons for this hearing. Ground of Appeal 2 relates to point 2, Roman 2, and Ground of Appeal 3 relates to points Roman 1 and 3. Underlying all these points is a factual issue. What were the considerations upon which the Secretary of State's decision was based? Were they limited to concerns regarding LTN schemes? It is convenient to deal with this next. The 2022 guidance identified 9 measures for reallocating road space to people walking and cycling or active travel. The document states that none of the measures were new. They already formed, quotes, a standard part of the toolkit, close quotes. What the 2022 guidance did was to promote a, quotes, step change in their rollout, close quotes. One of the 9 measures was the use of quotes, modal filters, close quotes, to close roads to traffic by using planters or other barriers. Quotes, this can create low traffic or traffic-free neighbourhoods, close quotes. But the document did not say that this measure represented the only way of creating an LTN scheme. Another measure involves the introduction of pedestrian and cycle zones, restricting access by motor traffic at certain times, at all times. Such measures are also treated as LTN schemes in the ministerial briefing on the LTN review dated 31st of August 2023. The respondent considered concerns about, quotes, 15-minute cities, close quotes, in a submission by officials in March 2023, brackets, see paragraph 35 of the summary grounds of resistance, close brackets. The paper recognised that the government's ambition was to encourage active travel and modal choice, rather than restricting private car access or travel. It stated that the supplementary Section 18 guidance sought to embed and build on increases in active travel seen during the pandemic by reallocation of road space to people walking and cycling. That was an explicit reference to the Secretary of State's forward and to the 9 measures in the 2022 guidance. Officials advised that Section 18 guidance could be updated to state that measures which restrict vehicle movement are not favoured. They also advised that the 22 guidance could either be updated to remove reference to modal filters, or the guidance could be removed altogether, and new Section 18 guidance issued, taking, quotes, a stronger stance on traffic filters and measures which restrict vehicular movement, close quotes. Ministers requested further consideration of those options. The significant point is that from the outset, the respondents' concerns were not limited to only one out of the 9 measures in the 2022 guidance. There was a broader concern about measures restricting vehicular movement. On the 1st of August 2023, officials made a ministerial submission advising on next steps regarding LTNs. The paper put this issue into a wider context. An emerging policy document, quotes, Plan for the Motorist, close quotes, proposed that only those schemes restricting access for drivers that are well designed and have broad support would be taken forward. Paragraph 7 recommended that as a first step, the Section 18 guidance on, quotes, road space allocation for active travel, close quotes, be withdrawn. Paragraph 8 recommended the preparation of new supplementary guidance setting out how authorities should ensure that traffic management schemes are well designed and enjoy wide support. That suggestion was not limited to LTNs. In addition, authorities would be directed to use a toolkit developed by ATE to ensure rigorous, consistent assessment of proposals. Paragraph 9 advised that the new guidance should set high standards for community engagement in scheme development. There would be an opportunity for ATE to inspect a much wider range of schemes for compliance with the guidance. Brackets, paragraph 10, close brackets. The briefing referred to research commissioned on 20 large, quotes, active travel, quotes, close quotes, schemes, including but not limited to LTNs, which would address inter alia modal shift. Open brackets, paragraph 13, close brackets. Ministers agreed to a note being sent to number 10 setting out that course of action and stating that the immediate withdrawal of the 2022 guidance would itself, quotes, send a clear message that things have changed, close quotes. Open brackets, paragraph 40 of the summary grounds of resistance, close brackets. The judge also referred at 22 to 23 of her judgment to a, quotes, tactical update note, close quotes, submitted to ministers in August 2023 with an annex. A further ministerial submission was made on the 31st of August 2023, seeking approval for the approach proposed for the departmental review of LTNs. It was noted that an additional evaluation of the impacts of, quotes, various types of schemes, brackets, including LTNs, close brackets, close quotes, funded by the Active Travel Fund, had already been carried out, brackets, paragraph 5, close brackets. It was proposed that updated Section 18 guidance be considered, which could address the use by local authorities of traffic management measures, open brackets, paragraph 8, close brackets. Officials recommended that the 2022 guidance be withdrawn. The advice it contains, quotes, now feels dated and no longer in line with ministerial priorities. Full stop. We would look to replace it in due course with new guidance shaped by the outcomes of the LTN review, close quotes, open brackets, paragraph 9, close brackets. Ministerial approval was given to the withdrawal of the 2022 guidance on the 12th September 2023. This decision to withdraw was announced on the 2nd of October 2023, the same day as the publication of the policy paper, quotes, the plan for drivers, close quotes. It appears that draft Section 18 guidance was published in March 2024 alongside the report of the LTN review. Consultation with key stakeholders was to take place by the 24th of May 2024. That was the date on which Parliament was prorogued prior to the general election that year, and so that process did not continue. In my judgment, the judge was entitled at paragraph 52 to accept the respondent's submission in paragraph 45 of the summary grounds of resistance that the withdrawal of the 2022 guidance was not solely concerned with LTNs. It was part of a wider emerging policy that the shift to sustainable transport should be delivered in a way that was less hostile to the interests of drivers and to encourage authorities to develop new traffic measures, including but not limited to LTNs, with increased community involvement. The government wished to replace the 22 guidance with an updated policy. I would add straight away that, of course, the merits of any policy or changing policy have nothing to do with the court's consideration of this proposed application for judicial review. Paragraphs 31 and 32 of the appellant skeleton, with respect, fail to grapple with the judge's careful analysis of the 2022 guidance and the sequence of submissions made by officials to ministers. Paragraph 31 selectively criticises the judgment at 55. Paragraph 32 ignores the references in the submissions to active travel and other matters, in addition to LTNs. When dealing with the 2022 guidance, the briefing referred to the active travel measures and the reallocation of road space to cycling and walking, which had formed the subject of the 2022 guidance. With regard to climate change and air quality, the 2022 guidance barely referred to those matters. The climate change issue was addressed in a cross-reference to the Transport Decarbonisation Plan. That was all. The withdrawal of the 2022 guidance did not affect that plan. It is not arguable that the briefing to ministers was legally deficient, applying the approach approved in the King, brackets, a Save Stonehenge World Heritage Site Limited, close brackets, against Secretary of State for Transport, 2024 EWCA Civ 1227, semicolon, 2025 PTSR 726, at paragraphs 91 to 97. The briefing did not fail to draw attention to some obviously material consideration. Instead, the briefing in March 2023 stated that the 2022 guidance had intended to build on and embed increases in walking and cycling seen during the pandemic, a plain reference to the Secretary of State's forward. In my judgment, all of the appellant's contentions raised under point Roman 2 are unarguable. Point 3, Roman 3, is also unarguable. It wrongly assumes that the reasons for the changes in policy direction were limited to LTNs. That leaves point Roman 1. It is contended that the respondent acted disproportionately by withdrawing the whole of the 2022 guidance when the government's concerns were related only to LTNs. As the judge rightly pointed out at paragraph 50, there is no allegation in this case of a breach of the Capital's ECHR or of a fundamental common law right. Disproportionality is not a freestanding ground of challenge in judicial review. Instead, Mr. Hong submits that disproportionality may support an allegation of irrationality. She relies inter alia on Reid against Secretary of State for Scotland, 1999, 2 appeal cases 512 at 541G, and McGrath against Secretary of State for Work and Pensions, 2012 EWHC 1042, brackets admin close brackets, at paragraph 33. Likewise, the submission that a decision is unlawful where manifestly disproportionate weight is being given to a consideration depends upon the irrationality principle, open brackets Humber Landlords Association, against Hull City Council 2019 EWHC 332, open brackets admin, close brackets, at paragraph 57, close brackets. In this context, it should be remembered that the court is dealing with policy making at the national level in the macro-political field by a minister accountable to Parliament. The legal approach to cases of this nature is sensitive to the circumstances involved, but in my judgment, a relatively, quote, light touch, close quotes, or, quote, low intensity of review, close quotes, is required here. Open brackets, see, for example, the Queen, open brackets, Packham, close brackets, against Secretary of State for Transport, 2020 EWCA Civ 1005, 2021 Environment Law Reports 2015 at paragraphs 47 to 51, close brackets. In any event, the complaint is unarguable. As I previously explained, the decision to withdraw the 2022 guidance was based on wider considerations requiring the guidance to be altered than simply concerns about LTN schemes. You cross heading ground 4. The appellant submits that the respondent's decision was irrational because, firstly, it was founded on an error of logic, or secondly, there was no evidence to support an important step in the decision-maker's reasoning. The appellant seeks to criticise a statement made by the Secretary of State in Parliament, where he referred to the 2022 guidance as, quote, outdated COVID guidance, close quotes. That argument could give rise to issues under Article 9 of the Bill of Rights of 1689, but in any event, the appellant relies upon further material in pre-action disclosure by the respondent. First, a ministerial submission stated that some commitments in gear change were a response to the pandemic, which was no longer appropriate, The focus there on the rapid rollout of LTNs no longer reflected current political priorities. Second, a ministerial submission referred to the guidance as having been first issued at the height of the pandemic and revised in 2022, and the advice it contains, quotes, feels dated, close quotes, and no longer reflects current political priorities. The appellant submits that a, quote, serious logical error, close quotes, was made in that the Secretary of State failed to appreciate that for 2 years the guidance had ceased to operate as COVID guidance and was meant to be in place long term with the intention of, quotes, making permanent and capitalising on the changes made during the pandemic, close quotes. I would not have described this complaint as relating to an error of logic. Instead, the allegation was simply that the decision maker had misunderstood his own policy. Indeed, that is how the point is now put in the skeleton for the hearing before this court. It is said that the guidance was amended in 2022 so that it no longer focused on COVID measures, but aimed to embed active travel well into the future, at least 2050, given the reference in the guidance to the transport decarbonisation plan. In my judgment, there is nothing here which could be said to amount to an arguable error of law. First, it would have been obvious to officials and to the respondent that the pandemic had ended. Briefing to ministers made it clear that the guidance had been updated in April 2022 and sought inter alia to embed and build on increases in walking and cycling during the pandemic. But by October 2023, the respondent's policy approach had changed to the extent that she considered it necessary to withdraw the guidance and to set in motion an updating of that document. The reasoning which led to that decision betrays no arguable error of law in understanding the published guidance. The 2022 version did not indicate that it would remain in place for a lengthy period of time. Policies on active travel, such as the Transport Decarbonisation Plan, remained in place. But the respondent decided to alter the approach taken in the Section 18 guidance to that subject, as she was entitled to do. She was also entitled to treat the guidance as out of date, in the sense that it did not reflect the altered approach that she wished to pursue. The appellant's case is really a disagreement about the merits of the change in approach, the merits of that change in approach. The appellant's skeleton argument, in my judgment, reveals that the, quotes, no evidence, close quotes, complaint is not based upon any additional point. It simply recycles contentions which I have already addressed. Cross-heading, conclusion. I would refuse the applications for permission to appeal against the order of Mrs. Justice Heather Williams and for permission to apply for judicial review.
I agree.
I also agree.
My lord, the question of costs, I do apply for my costs. There is a schedule which was CE filed and sent by email on Wednesday. I have copies in case it hasn't reached your lordship.
If you have a copy, certainly speaking for myself, I could do with it.
Yes.
Have you got it? Do you have 2 copies? One for me, one for Lady Justice Andrews.
I'm afraid it isn't stapled. The position as far as costs are concerned is that this court's order of the 14th of February this year applies the cost cap of £25,000
Yes.
pounds to these proceedings. So far, the claimant has been ordered to pay £14,000 in the High Court's order at page 32. As the order for an oral hearing directs the Secretary of State to attend, my submission is that if, as the Secretary of State has been successful, although in the event didn't need to be called on, should be entitled to recover costs. The cost schedule is in the sum of £15,000, which is more than the 11,000 remaining in the cost cap. So I would simply.
So you accept that the most you can apply for is 11,000?
I'm not seeking to vary the cap, so that's the most I would seek. So insofar as there are any minor issues with the amount, those won't take it down below 11,000. So that, in my submission, should simply be the order that's made.
Yeah. So is the answer to my question? Yes.
Indeed.
11,000 is the maximum you see. Yeah. Fine. All right. Thank you very much. Yes, Mr. Hon, what do you say about costs?
My Lord, I'm grateful. Two things. First, an overarching thing, and then second, if that doesn't find favour, a fallback position.
Yeah.
First, the overarching submission, which is, although I appreciate that Lady Justice Andrews' order asked the respondent to appear, and therefore made it plain that the respondent may be able to have costs, in the way in which it has played out, the respondent was not called on, and Lord Justice Holgate's judgment referred throughout to the skeleton arguments, not really to any of the arguments that were heard orally. In those circumstances, I have two things to say. The first is that the primary position should be that the respondent should not obtain costs. But if that's not going to find favour, then the fallback position would be, and that's because it's not in line with fairness and the overriding objective, but the fallback position would be the extent of the costs available, if any costs are to be awarded, should only be the costs limited to the attendance of today, not any other costs that would not usually be able to be recouped. It's difficult to see what the specific costs just limited to the attendance of today are in the cost schedule, but I understand that they wouldn't be anything more than around £1,000.
Well, there'd be council's brief fee for coming here.
Yes, that's £300 as I understand. But the costs that would not usually be able to be recouped should not become able to be.
But what are those costs that would not usually?
Well, it's difficult, as I say, from the cost schedule to see. But
the difficulty is that we all think twice about calling things in, but sometimes it's the best and most efficient way of dealing with a potentially important PTA. This is the first of 3 Fridays that I should be spending dealing with called-in PTAs for that reason.
Yes.
And when you call them in, you don't necessarily know what the points are going to be, but you want the assistance of both sides as a matter of principle when you call it in.
Yes.
Which is hence my lady's order.
Yes, but
and so in those circumstances, since the attendance is required for good reason, it's a bit tough then to say, oh well, things like preparation and so on are somehow irrelevant, and it's just the attendance on the day.
Well, certainly the costs that would have been incurred in the usual event in preparing the 3-page response should not be recoverable, despite the fact that there has been subsequent attendance. I absolutely understand that the costs of preparing to attend today are much more justifiably recoverable.
I apologise. The cost schedule I thought I had turned out to be a different cost schedule.
My lord.
Yeah, I think if you've got another copy, then.
It's not really.
Sorry for that.
A brief point, just on that specific point about the cost of the written schedule, my lord, if I may, the written statement, if I may. The justification for not requiring, as it were, a full skeleton argument from the respondent for today's hearing from the court was that the respondent had already put in the written statement. So
Part
those costs,
19,
Paragraph 19.
paragraph 19
yes.
statement. Yeah.
So in effect, there's no duplication. Those costs represent costs that
Would otherwise have been incurred in writing a skeleton argument.
exactly. So
All right, well, we understand the point. We'll just rise just to deal with costs, but don't, I see the time, don't go away.
All right.
Well,
The issue that arises finally in this application for permission to appeal is costs. We have refused the renewed application for permission to appeal. In those circumstances, the respondent is the successful party and is in principle entitled to its costs. The fact that the permission application was called in for an oral hearing is in one sense nothing to the point. When those orders are made, the Lord or Lady Justice making the order does not know what the arguments are going to be and how it's going to pan out, and therefore it is always of assistance to have the respondent there on any renewed oral application. So the position is that the applicant takes the risk by making an application for a renewed permission to appeal that they, if unsuccessful, will have to pay the costs. So as a matter of principle, it's plain that the applicant should pay the respondent's costs. The cost schedule comes to over £15,000. There are some elements of that which we think are overstated, but we don't need to go into the detail of that because Mr. Ormondroyd accepts that the maximum costs that the respondent can recover for this case as a whole has been capped at £25,000. The applicant already has to pay £14,000 arising from the application in the High Court, and therefore the respondent's costs on this application are limited to £11,000, and therefore there is a reasonable margin for error between the maximum that the respondent can recover of £11,000 and the sum claimed of over £15,000. So in those circumstances, given A, the principle, and B, the margin for error, we are agreed that the respondent should have its costs in the sum of £11,000. Right. As the clock dings 1, can I say thank you very much to both of you, and that concludes the hearing. Thank you.
All right.